Imagine standing on a piece of land you legally bought, paid taxes on for 5 years, and cleared with your own hands, only to look down the barrel of a county deputy's flashlight while handcuffs click around your wrists. For Arthur Vance, a 52-year-old retired civil engineer, the dirt beneath his boots wasn't just real estate, it was his life savings. Yet, on a rainy Tuesday evening, Sheriff Thomas Miller personally signed the arrest warrant that branded Arthur a criminal trespasser on his own property. The system didn't care about Arthur's receipts, his fences, or his sweat. To the local authorities, he was an invader occupying land that belonged to the county's most powerful developer. But neither the sheriff nor the billionaire developer realized that Arthur wasn't just a squatter, he was a man holding a weapon they completely overlooked, a certified, unassailable chain of title. The conflict began quietly, as most devastating legal storms do, buried under layers of mundane administrative paperwork in the low-ceilinged basement of the Madison County Recorder of Deeds. Arthur Vance had purchased the 80-acre parcel known as Miller's Ridge at a municipal tax foreclosure auction 5 years prior. The land had belonged to a defunct lumber corporation that abandoned its corporate charter in the late 90s, leaving behind decades of unpaid property taxes. Arthur, meticulous by nature due to his 3 decades of calculating structural load tolerances for municipal bridges, spent 8 months auditing the county land records before ever bidding a single dollar. He verified the tax liens, confirmed the publication notices, and ensured the foreclosure process strictly adhered to State Code Section 44A regarding delinquent property liquidations. When the auction gavel fell, Arthur paid $64,000, his entire retirement windfall, for a validly executed sheriff's deed. For 5 years, Arthur lived in a modest, self-built cabin on the northern ridge, completely undisturbed. He cleared the invasive brush, reinforced the access roads, and paid his annual property assessments directly to the county treasurer, receiving stamped receipts every December. To the rest of Madison County, the ridge was a useless, rocky outcropping. To Arthur, it was sanctuary. Everything changed when the State Department of Transportation announced the construction of the new Interstate 85 bypass route, which was scheduled to cut directly through the valley less than a quarter-mile from Arthur's southern boundary line. Overnight, the rocky, useless outcropping of Miller's Ridge became the most strategically valuable commercial real estate in the Tri-County area. It was the perfect staging site for logistics hubs, concrete mixing plants, and heavy equipment storage. Enter Vanguard Holdings, a private real estate development conglomerate directed by Charles Caldwell, a third-generation real estate mogul whose family name adorned the local community college and the hospital wing. Caldwell needed Miller's Ridge to secure his $100 million state logistics contract. The problem was Arthur's cabin was sitting right where the primary heavy transport access road needed to go. Caldwell's legal team didn't offer to buy Arthur out. Instead, they searched for a vulnerability. They dug through the county's archaic microfilmed records and discovered a clerical anomaly from 1984, a poorly drafted easement agreement between the long-dead lumber corporation and Caldwell's grandfather. The easement purported to grant the Caldwell family perpetual right-of-way and possession for operational maintenance over the entirety of the ridge's southern flank. Seizing on this ambiguous, 40-year-old document, Caldwell's attorneys filed an expedited corporate affidavit claiming that the subsequent tax foreclosure in 2021 had failed to properly extinguish their senior possessory interest. Arthur first learned of the threat when a private surveyor contracted by Vanguard Holdings began driving neon orange stakes across his front gravel driveway. When Arthur politely asked the surveyor to leave his private property, the man laughed, pointing to a clipboard. "This isn't your dirt anymore, Chief. Vanguard owns the right of entry. Check the county registry." Arthur immediately drove to the courthouse, his heart hammering against his ribs. He requested the updated tract index for his parcel. There, scrawled in the margins of the digital ledger, was a newly recorded notice of conflicting claim and possessory right, stamped by the county clerk just 48 hours prior. Caldwell hadn't sued Arthur yet, he had simply weaponized the recording system to create a cloud on Arthur's title, making the land legally toxic to anyone else while asserting a right to immediate occupancy. Arthur refused to back down. He relied on basic property law. A validly executed tax deed cleanses the title of prior junior encumbrances if proper notice is given during the foreclosure. He drafted a formal, certified cease and desist letter, attaching a copy of his 2021 sheriff's deed, and sent it to Vanguard Holdings corporate office via registered mail. Caldwell's response wasn't a legal brief. It was a phone call to Sheriff Thomas Miller. The Caldwell family had been the primary financial contributors to Sheriff Miller's re-election campaigns for over a decade. In a small, economically depressed county like Madison, lines between private corporate interests and local law enforcement often blurred at the edges of town. The sheriff didn't review the underlying real estate chain of title, he didn't consult the county civil attorney. He looked at a corporate affidavit submitted by Caldwell's high-priced lawyer stating that an illegal squatter was actively obstructing a multi-million-dollar infrastructure project and threatening licensed contract workers. On that rainy Tuesday evening, 2 marked patrol cruisers ascended the gravel road to Miller's Ridge, their tires churning the mud into deep ruts. Arthur stood on his porch, holding nothing but a manila folder containing his original deed. He expected a conversation. He received a demand to vacate within 10 minutes. When Arthur stood his ground, citing his constitutional property rights, Deputy Regional Supervisor Higgins pulled his cuffs. Arthur was charged with criminal trespass in the first degree, a misdemeanor elevated to a felony due to the alleged obstruction of a public infrastructure pathway. As the cruisers rolled down the mountain, leaving his cabin dark and unprotected, Arthur looked out the back window to see a Vanguard Holdings bulldozer idling at the base of his ridge. The interior of the Madison County Jail smelled of industrial disinfectant and stale damp air. For Arthur Vance, the experience was profoundly disorienting. He was a man who spent his life adhering to precise measurements, regulations, and codes. Being stripped of his belt, shoelaces, and personal belongings felt like an absolute breakdown of the logic he lived by. He was placed in a holding cell with a concrete bench and a single scratched plexiglass window overlooking the booking desk. Through that window, Arthur watched the system work against him. He saw Sheriff Miller chatting amiably with a man in a tailored charcoal suit, Marcus Vance, no relation, the lead outside counsel for Vanguard Holdings. It became instantly clear that his arrest wasn't an administrative mistake. It was a tactical eviction executed under the color of criminal law. Arthur spent the night awake, staring at the fluorescent light fixture overhead. His mind didn't panic, instead, it fell back on his engineering training. He analyzed the problem. Vanguard Holdings wanted him off the land immediately so they could begin earth-moving operations. In real estate development, speed is everything. If a developer can clear land, alter the topography, and lay gravel before an injunction can be filed, the legal doctrine of latches, or the sheer practical reality of irreparable change, makes it incredibly difficult for a court to restore the original state of the property. They didn't need to win a long-term lawsuit, they just needed him out of the way for 30 days while the state logistics contracts were finalized. The next morning, disheveled and still wearing his mud-stained work shirt, Arthur was brought before Magistrate Judge Evelyn Alvarez for his initial appearance. Standard procedure for a first-degree criminal trespass charge dictated a modest cash bail, but the state's prosecutor, working off a brief prepared overnight by Vanguard's legal team, argued that Arthur constituted a flight risk and a threat to public infrastructure development. They requested an exorbitant $50,000 bond. Fortunately for Arthur, the public defender assigned to the morning roster was Sarah Jenkins, a sharp, chronically overworked attorney who took an immediate interest in the anomalies of Arthur's paperwork. When Arthur handed her the damp manila folder he had managed to keep with him until booking, Sarah didn't see a crazy squatter. She saw a validly executed, certified sheriff's deed with an unblemished recording stamp from 5 years prior. "Your Honor," Sarah argued, stepping up to the wooden podium, "this is not a criminal trespass matter. This is a highly complex, pre-existing civil property dispute. My client holds a valid tax deed to the parcel in question. The complaining witness, Vanguard Holdings, is using the county sheriff's department as a private security force to bypass the standard civil eviction process." Judge Alvarez, looking through her reading glasses at the paperwork Sarah presented, frowned. She looked at the prosecutor, then at the certified deed. In a small county, judges are highly protective of judicial economy. They despise when corporations use the criminal courts to resolve quiet title actions. "I am not going to litigate property lines in a morning bond hearing," Judge Alvarez declared, her voice echoing in the sparse courtroom. "However, the existence of a recorded deed creates a colorable claim of right. The defendant is released on his own recognizance. But Mr. Vance, I am ordering a temporary status quo restriction. You are not to interfere with ongoing municipal infrastructure surveys until this matter is clarified. Arthur was free, but he was effectively locked out of his own home. The minute he stepped outside the courthouse, he saw the true scale of the trap. He called an old colleague from his engineering days who lived near Miller's Ridge. The news was bad. Vanguard Holdings had already moved 3 heavy excavators up his access road. They weren't just surveying, they were clearing the trees along his southern border, preparing to lay down a commercial-grade sub-base for the heavy transport lane. Arthur knew that if he waited for a standard civil trial, which could take anywhere from 18 to 24 months in the backlogged county circuit court, his cabin would be demolished, his trees would be gone, and the land would be permanently altered. He needed an emergency intervention. He needed a temporary restraining order, TRO, against Vanguard Holdings and the Madison County Sheriff's Department to halt all activity on the parcel. Sarah Jenkins couldn't represent him in a private civil matter due to the limitations of her public defender mandate, but she pointed him toward a retired real estate attorney named David Thorne, who ran a quiet practice out of a converted brick home 3 blocks from the courthouse. Thorne was 70 years old, knew every inch of the county land registries, and had no fear of Charles Caldwell or Sheriff Miller. Sitting in Thorne's office, surrounded by stacks of leather-bound law books, Arthur laid out his documents: the 2021 tax deed, the tax payment receipts for the past 5 consecutive years, the original title insurance policy, and the certified letter he had sent to Vanguard's corporate office. Thorne adjusted his glasses, examining the chain of title with a practiced eye. "They are counting on you being broke and intimidated, Arthur," Thorne said, his voice a low, gravelly rumble. "They are relying on that 1984 easement. But what Caldwell's lawyers conveniently ignored in their corporate affidavit is the state Supreme Court ruling from 2012, City of Riverdale versus Estate of Montgomery. That ruling clearly states that a judgment of foreclosure for delinquent taxes extinguishes all prior easements, covenants, and rights of way if the holder of those interests was given proper constructive notice via publication. The county published the notices for 4 consecutive weeks before your auction. Vanguard's predecessors simply failed to protect their interest." Thorne looked up, a sharp smile breaking through his weathered face. "We are going to file an emergency petition for a quiet title action and a motion for a preliminary injunction. And we're going to get it in front of Circuit Judge Robert Vance, no relation to you, but a man who treats the integrity of the land records like Holy Scripture." The battle lines were drawn, but the clock was Arthur's greatest enemy. While David Thorne spent the next 48 hours drafting the emergency petition for a temporary restraining order, Vanguard Holdings wasn't wasting a single second. From his friend's property across the valley, Arthur watched through binoculars as the heavy machinery tore into Miller's Ridge. The ancient oaks along his southern boundary line, trees that had stood for nearly a century, were ripped from the earth by hydraulic excavators. The low hum of diesel engines vibrated through the air from dawn until long after dusk. Caldwell's strategy was blindingly obvious to an experienced civil engineer like Arthur. They were rushing to establish substantial completion of the infrastructure corridor. If the road was already graded, packed with gravel, and integrated into the state's bypass network, a judge would be highly reluctant to order its physical destruction, regardless of who held the underlying deed. On Thursday afternoon, David Thorne officially filed civil case file number 26, CV-0412, Arthur Vance vs. Vanguard Holdings LLC and the Madison County Sheriff's Department. Because Thorne requested emergency relief to prevent irreparable harm, the clerk fast-tracked the motion to Circuit Judge Robert Vance's chambers for a preliminary injunction hearing the very next morning at 9 o'clock. When Arthur arrived at the courthouse on Friday, the atmosphere was thick with corporate influence. Marcus Vance, the elite corporate litigator representing Vanguard Holdings, sat at the defense table flanked by 2 junior associates carrying leather litigation bags. Sitting directly behind them in the first row of the gallery was Charles Caldwell himself, exuding the casual confidence of a billionaire who viewed local courtrooms as mere administrative rubber stamps. Across the aisle sat Sheriff Thomas Miller, attending the hearing in full uniform to defend his department's execution of the trespass arrest. Judge Robert Vance ascended the bench precisely at 9. He was a silver-haired jurist known throughout the state for his encyclopedic knowledge of real estate law and his zero-tolerance policy for procedural shortcuts. He adjusted his microphone and looked down at the pleadings. "We are here on an emergency motion for a preliminary injunction and a petition to quiet title regarding Parcel 412B, commonly known as Miller's Ridge, Judge Vance began, his voice calm but commanding. The plaintiff alleges that the defendants are actively destroying real property under a disputed claim of right, while using criminal statutes to exclude the record title holder. Mr. Thorne, you have the floor. David Thorne stood up, buttoning his vintage tweed suit coat. He didn't offer a dramatic speech. Instead, he stepped directly to the lectern and opened a blue binder. Your Honor, this case is fundamentally about the sanctity of our county land recording system. My client, Arthur Vance, purchased this 80-acre parcel at a validly executed municipal tax auction 5 years ago. We have submitted Exhibit A, which is the certified sheriff's deed, signed, sealed, and recorded in Book 1402, page 88 of the Madison County Registries. For 5 years, my client has been the sole occupant and the exclusive taxpayer for this parcel. Thorne paused, turning to look directly at Marcus Vance. On Tuesday evening, the Madison County Sheriff's Department, acting at the behest of a private corporate entity, bypassed all civil eviction protocols, entered my client's home under the cover of night, and arrested him for felony criminal trespass. This was done to allow Vanguard Holdings to move heavy machinery onto the land and destroy its topography before this court could review the file. This is a textbook example of irreparable harm, and we ask for an immediate freeze on all construction activity. Judge Vance nodded slowly, making a precise note on his legal pad. He then turned his gaze toward the defense table. Mr. Vance, let's hear from Vanguard. Why shouldn't I grant this injunction today? Marcus Vance stood up smoothly, adjusting his silk tie. He smiled warmly at the bench, projecting total authority. Your Honor, this is a matter of critical state infrastructure, not a simple property dispute. Vanguard Holdings holds a senior possessory interest via a perpetual easement granted in 1984 by the original owners of the Ridge, the Madison Lumber Corporation. That easement was specifically intended to facilitate the construction of transport corridors. The plaintiff purchased this land at a bargain basement tax sale knowing, or at least, he should have known, that a recorded, perpetual corporate easement ran with the land. The corporate lawyer stepped closer to the bench, raising a finger for emphasis. Furthermore, my client has already invested over $400,000 in clearing and grading this corridor to meet strict State Department of Transportation deadlines. Stopping construction now would cause massive financial penalties to the county and delay a project that benefits thousands of local citizens. Mr. Vance was arrested because he was physically blocking licensed surveyors and creating a hazardous situation on an active industrial site. The sheriff acted entirely within his statutory authority to maintain public safety. To an outside observer, the developer's arguments sounded formidable. They had history, they had massive investments, and they had the backing of local law enforcement. But Arthur, sitting quietly next to Thorne, noticed that Judge Vance hadn't looked at Marcus Vance once during his speech. Instead, the judge was intently flipping through the pages of the certified tax deed Arthur had provided. The courtroom was dead silent as Marcus Vance finished his presentation. He sat down, smoothing the front of his charcoal suit jacket, confident that the staggering figure of $400,000 in sunk costs and the invocation of critical public infrastructure would sway the court. In many jurisdictions, the practical reality of massive corporate investment acts as an invisible weight on the scales of justice. But Judge Robert Vance remained unmoved. He looked over the rim of his reading glasses at the plaintiff's table. Mr. Thorne, Judge Vance said, his pen hovering over his notepad. The defense has raised a significant point regarding the 1984 perpetual easement. A recorded easement running with the land typically survives subsequent transfers of ownership. How do you answer the claim that your client's tax deed is subject to this pre-existing senior right-of-way? David Thorne stood up slowly, leaning heavily on the wooden podium. He didn't look like a high-priced corporate litigator, but his eyes possessed the absolute certainty of a scholar who spent 40 years memorizing the state's property codes. Your Honor, the defense is relying on a foundational rule of property law while intentionally ignoring the statutory exceptions that govern tax foreclosures, Thorne began, his voice clear and resonant. It is true that a standard private sale preserves validly recorded senior easements. However, a municipal tax foreclosure is not a standard private sale. It is a sovereign exercise of the state's power to enforce its revenue laws. Thorne opened his blue binder and pulled out a certified copy of a legal opinion, passing it to the bailiff to deliver to the judge. We submit Plaintiff's Exhibit B, the state Supreme Court's definitive ruling in City of Riverdale v. Estate of Montgomery. Under this controlling precedent, when a municipality forecloses on a tax lien, the resulting tax deed completely cleanses the title of all junior encumbrances, including prior mortgages, judgment liens, and private commercial easements, provided that the holders of those interests were given proper notice under State Code Section 44A. Marcus Vance sat up straight, his confident posture instantly hardening. He signaled to one of his junior associates, who frantically began typing into a laptop, searching the digital law databases for the citation Thorne had just provided. Thorne continued, turning to look directly at the developer, Charles Caldwell. The Madison County Treasurer's Office foreclosed on the defunct Madison Lumber Corporation after 10 years of non-payment. The county strictly followed the statutory notice requirements. They published the foreclosure notices in the Madison County Chronicle for 4 consecutive weeks in the fall of 2020. Vanguard Holdings' corporate predecessors had a legal obligation to monitor the tax status of the property over which they claimed an interest. They failed to pay the delinquent taxes to protect their easement. They failed to appear at the foreclosure hearing. Consequently, when the gavel fell and my client was issued his sheriff's deed, that 1984 easement was legally, permanently extinguished as a matter of law. Judge Vance looked at the copy of the Supreme Court ruling Thorne had provided. He spent nearly 3 minutes reading the text in absolute silence, the only sound in the courtroom being the rhythmic ticking of the wall clock. Mr. Marcus Vance, the judge said finally, his voice dropping to a dangerous register. Have you read City of Riverdale v. Estate of Montgomery? The corporate defense attorney stood up, his face noticeably paler. Your Honor, my team is reviewing the specific facts of that case right now. But we contend that our easement is distinct because it involves an active transport corridor vital to a state-funded infrastructure project. The law does not care about your timeline, Mr. Vance, Judge Vance interrupted, his palm coming down firmly on the bench. The Supreme Court ruling is absolute. A valid tax foreclosure wipes the slate clean. If your client wanted to preserve their perpetual right-of-way, they should have paid the $64,000 in back taxes that the Lumber Corporation owed the county. They chose not to. They slept on their rights. The judge then turned his gaze toward Sheriff Thomas Miller, who was shifting uncomfortably in his uniform in the front row. Furthermore, I am deeply troubled by the procedural timeline of this matter. A criminal trespass charge requires an unlawful entry without a colorable claim of right. Mr. Arthur Vance presented your deputies with a certified, recorded deed to the property. That is not a criminal trespasser, that is a record title holder engaged in a civil ownership dispute. To use the criminal courts and the county jail to execute a forced eviction without a judicial order is an egregious abuse of process. Charles Caldwell leaned forward, whispering harshly into his attorney's ear, his face flushed with sudden anger. The narrative had completely flipped. The developer's team had walked into the courtroom expecting to crush a squatter, they were now realizing they were the ones operating outside the boundaries of the law. This court finds that the plaintiff has demonstrated a substantial likelihood of success on the merits, Judge Vance announced, his gavel raised. Furthermore, the ongoing destruction of the natural topography of Miller's Ridge constitutes clear, irreparable harm. Judge Robert Vance did not hesitate. He brought his gavel down with a sharp, resonant crack that echoed off the high oak ceilings of the courtroom. The era of Vanguard Holdings treating the local municipal records as a private playground was officially over. It is hereby ordered, Judge Vance announced, reading directly into the court record, that the plaintiff's motion for a preliminary injunction is granted in full. Vanguard Holdings LLC, its officers, contractors, and agents are ordered to immediately cease and desist all clearing, grading, excavation, and construction activities on Parcel 412B. All heavy machinery must be removed from the property within 24 hours. The judge paused, turning a stern, unyielding gaze toward the defense table where Marcus Vance stood frozen. Furthermore, a temporary status quo order is placed on the Madison County Sheriff's Department. Law enforcement is strictly prohibited from executing any further criminal arrests or removals against Mr. Arthur Vance regarding this parcel without an explicit, written civil eviction order issued directly by this court. If a single blade of heavy equipment touches that dirt past noon tomorrow, I will hold Vanguard Holdings in structural civil contempt, carrying fines of $10,000 per day. Charles Caldwell stood up abruptly in the gallery, his face dark with fury, and marched out of the courtroom, the heavy double doors swinging violently behind him. His high-priced legal team scrambled to gather their binders and laptops, their carefully constructed aura of corporate invincibility completely shattered by a single, 70-year-old lawyer wielding a basic municipal tax statute. Outside the courtroom, the air felt lighter. Arthur Vance stood on the courthouse steps, holding his manila folder, watching the frantic retreat of Vanguard's legal entourage. David Thorne patted him on the shoulder, a weary but deeply satisfied smile on his face. "The preliminary injunction is ironclad, Arthur," Thorne explained, adjusting his coat. "But remember, this was just the first battle. They still have 30 days to answer our formal quiet title petition. However, now that the judge has clearly stated that their 1984 easement was legally extinguished by the tax foreclosure, Vanguard has absolutely no leverage. They cannot build their access road, which means their $100 million state logistics contract is completely paralyzed." Thorne's prediction proved entirely correct. Deprived of the ability to use the criminal courts as a blunt instrument for eviction, Vanguard Holdings was forced to play by the rules of civil procedure. Over the next 3 weeks, their legal team tried desperately to find a loophole in the 2012 City of Riverdale precedent, but the statutory language was clear and unyielding. The municipal tax sale had wiped the slate clean. Because the State Department of Transportation contract had strict, non-negotiable construction deadlines, Caldwell couldn't afford a protracted, 2-year quiet title trial. Every week his machinery sat idle cost his conglomerate tens of thousands of dollars in delay penalties. The corporate giants who had tried to arrest Arthur under the cover of night were suddenly forced to sit across a conference room table from him. On the third week following the hearing, Marcus Vance extended a formal settlement offer on behalf of Vanguard Holdings. They offered to purchase Miller's Ridge from Arthur for $450,000, more than 7 times what Arthur had paid for it at the county tax auction. Arthur turned it down. He didn't want their corporate payout, he wanted his sanctuary. Instead, Arthur leveraged his engineering background to dictate his own terms. He agreed to grant Vanguard a highly restricted, narrow easement along the absolute southernmost boundary of the property, far away from his ridge and his cabin, ensuring his privacy remained entirely intact. In exchange for this concession, Vanguard Holdings was forced to pay Arthur a significant financial settlement to cover the restoration of the oak trees they had illegally cleared. Completely pay off his legal fees, and fund the construction of a permanent, structural privacy barrier between his cabin and the new transport lane. The consequences extended far beyond Vanguard's corporate offices. The public exposure of the hearing sent shockwaves through the Madison County administration. Facing a massive civil lawsuit for malicious prosecution and civil rights violations under Section 1983, the County Board of Commissioners pressured Sheriff Thomas Miller to step down. The era of local law enforcement acting as a private security detail for wealthy campaign contributors had suffered a permanent public blow. 2 months later, Arthur stood on the porch of his cabin on Miller's Ridge. The heavy excavators were gone, replaced by the natural quiet of the mountain. At the base of the ridge, a team of professional arborists hired at Vanguard's expense were carefully planting mature, native trees to replace the ones that had been destroyed. The story of Miller's Ridge became a foundational warning told among regional real estate developers: the system is only as powerful as the paper it is built on. Vanguard Holdings believed that money, influence, and a badge could rewrite the law. But in the end, they were completely dismantled by a retired civil engineer who knew that a validly recorded deed, backed by the unyielding letter of the law, is an unassailable fortress. Arthur looked out over his land, his hand resting on the smooth wood of his porch railing. The dirt beneath his boots was finally, undeniably, his own.